Good afternoon. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm also the employment practice lead for Western Canada. I'm joining you today to discuss employment law and employment rights. We're here for the employment law question and answer period for Samfiru Tumarkin. I'm here to answer any and all questions you have related to your job, your employment, your boss. Feel free to put those in the chat and we'll try to get to as many of those questions as we can. I'm coming to you from Calgary, Alberta, where we are in Stampede Week. A lot of employers, a lot of companies are holding Stampede events over the coming week for their staff, for their clients. And as always, we usually have this conversation more around Christmas time for Christmas parties. But I'd just like to remind everyone that a Stampede event held by your employer is a work event, and we often see, unfortunately, work events where things that happen that in the retrospect we wish hadn't happened, that sometimes can result in discipline. So I encourage everyone to enjoy the festivities responsibly, whether you are someone who's new to the organization, more involved, more experience with the organization. Health and safety legislation continues to apply at work events. If you're injured at a work event, you're likely entitled to the workers' compensation benefits. If you're a victim of harassment or anything like that, you also have entitlements under occupational health and safety. So feel free to reach out to us if any of that speaks to you. We are in the hottest week so far of the year here in Calgary. So I'll repeat what I said at my last appearance a couple of weeks ago, that you make sure if you're working outside or even if you're working inside in an environment that's not air conditioned, that you make sure to have breaks out of the sun. Again, health and safety is important. And if you feel that it's too hot for you to do your work safely, it's important that you say so. Don't wait till you've fainted and anything like that to happen before raising your hand and saying, I don't feel well. I don't think I can do this job safely, considering the heat. What can we do to make this job safer? Having a rest area that's cool, shaded, might be a solution. Having plenty of water on the work site might also be a solution. So think about that sooner rather than later, because this summer is going to get hot, as it's been hot in other parts of the country. It's getting hot here in the West Coast and in the western part of Canada. So we have our first question coming in here from Sammy. Sammy is asking, when are you allowed to record meetings in the workplace? Well, that's been a hot topic in employment law for the last year or so. There was a case that came out of BC where an employee was found to have been justly terminated for cause for recording, I think it was hundreds of hours of meetings and conversations and phone calls prior to his termination, and for no real good reason, just as a matter of course. This was someone that was recording conversations. And when the employer found out, they alleged that they had cause to terminate that employee, and a court of justice agreed with that assessment and held up the termination for cause. That said, it doesn't mean that it's never appropriate to record a conversation. There are some things you got to be aware of. Is it just a conversation between you and another person? If it is, then that's probably better than recording a meeting where a lot of people are attending, different people are discussing things, all right? Even if it's a one-on-one meeting, there has to be some kind of reason why you think it's important that it be recorded. For instance, recording a termination meeting. might be something that you want to do. If you're experiencing harassment at work, but it's impossible for you to prove it, it's one of those he said, she said, then at least you can claim that, listen, I recorded this because I had concerns about my health and safety, and this is the only way that I could substantiate my claim that I was being harassed or something like that, right? But if you're just a person that just systematically, every time you call your boss, you record the call, or every time you talk to a coworker, you record the call, and that can get you in a lot of trouble. All right, that can potentially lead to an employer saying that they don't have faith in you, that the trust that's required in any employment relationship has been broken. Now, when you're being harassed, that trust has already been broken quite a bit by the harasser, right? Who's trying to hide behind the fact that none of this is in writing to deny that they harassed you. So try to see, is there a real reason why you have to capture this in writing? If it's just par for the course, then I would recommend that you proceed cautiously. All right, because it has been held up in court that systematically recording your colleagues can amount to termination for cause. Now that's one decision, and I don't really think that here at the firm we agree with that. It's not criminal to record someone, even if they don't know you're recording one person. It is criminal to record two people talking if you're not part of that conversation. That's the equivalent of wiretapping, and wiretapping in criminal law requires a warrant, and you can't get a warrant if you're not a police officer. So surreptitiously recording the conversations of two other people, that is a definite no-no. I would stay away from that. Recording a meeting where you're participating already creates complications, really. We don't necessarily agree that there should be a blanket prohibition against recording anything at work. There are instances where it's the only way that you can prove your version of events, that you're being harassed, that you're being bullied, and things of that nature. And I would say that that's important. That's important. And also termination meetings, even termination meetings, just to make sure that everyone is on the up and up. But then again, may as well just ask, can I put my phone here to record this conversation, just so we're both protected? And then you would have no problem. Of course, if someone consents to being recorded, they can't then say, you weren't allowed to do that. We have a question coming in from YouTube. This is from Helen. Helen asks, I work in a sales position, and for months my manager made me use her sales ID to make my sales. This resulted in me not getting proper commission for the work I did and inflated her numbers and pay. I'm not sure what to do about this. What do you suggest? Well, it's definitely a form of wage theft if it's related to your compensation, and if you're being paid commissions, then it is related to your compensation. There are different avenues you can approach. You can go internally through the human rights procedure at your workplace, not human rights, human resources, and make a human resources complaint and see if it'll be investigated. You could also potentially make a complaint to employment standards to have your commission paid out to you. So you can make a complaint to employment standards that way. That's if you want to just have this issue fixed and you continue working with you being paid, being credited for the work that you actually did and for the sales that you actually closed, right? If, however, you're of the opinion, well, I don't want to work somewhere where I am the victim of wage theft on a consistent basis, well, it could be that you have a strong claim to constructive dismissal, in which case that would allow you to leave, to quit, but also quit because you're being forced to quit. You'd be able to claim your severance package. Now, I don't know how much severance you'd be owed based on the description you've given me, but you can easily find out how much severance you might be owed by visiting our website, pocketemploymentlawyer.ca, pocketemploymentlawyer.ca. We will ask you just 4 quick questions, completely anonymous, and that'll give you an estimation of how much severance you might be entitled to. And a severance might be as much as 2 years of compensation, of your full compensation. So it can be a substantial sum of money, depending on various factors. So definitely look into that, see what you're owed. If you're decided, listen, I don't want to work here anymore, the relationship of trust that I was just speaking about has been broken because my compensation is being stolen from me by my manager. So a few hurdles that you likely face is, do you have a record of which of these sales that you input in your manager's name that actually you're the one who closed, right? That would be the most important thing. How are you going to be able to prove that you closed those sales, right? That's going to be the challenge, especially if you're going through employment standards, because they're going to need some sort of list of what sales you should be credited for so that you can get the commission. If you just have even the start of one or two, then that's enough. I think that you can go to the human resources to have that investigated. So we'd have to have a better idea of how much money are we talking about here. How often did it happen? You said it was for months. That could potentially be quite substantial. So we'd have to get a few more details about that. Moving on to the next question coming up is from Linda B. Linda B asks, the business I work for is being sold at the end of the year, but there has been no talk of what is happening to staff. What happens if I'm not employed by the new owner? So the short answer is, if the company is sold and your new owner does not provide you with a new employment contract, then essentially you'll be terminated, all right? But you'll be terminated on a without cause basis by the old employer, and they will owe you severance, okay? And then once again, if you're trying to figure out how much severance am I owed, visit pocketemploymentlawyer.ca. That's the website on the screen. We'll ask you 4 quick questions, and you'll get an estimate of how much you might be owed in terms of months and in terms of dollars. So it can be a substantial sum. If, however, the new employer does decide that they want you to stay on, likely they're going to present you with an employment contract. And here's what you have to watch out for. That employment contract, you want to make sure, firstly, that they recognize your past years of service with the seller of the company, that you're not starting off as a day one employee with this new employer. And you want to look out for the termination clause, right? Because if you didn't have a termination clause with your old employer, you could be entitled to up to 2 years of severance if you're terminated. But your new employer might put in a termination clause that limits your entitlements there. And if they limit your entitlements, it might take that 2-year severance package that you might be owed and reduce it to something as low as potentially, a week per year to a maximum of 8 weeks. So a maximum of 2 months. So you've gone from 24 months to 2 months in this employment contract. So you want to watch out for that. You want to watch out for non-competition clauses and things of that nature. You want to look out for that. And if you are if you are being hired by your new employer, sometimes the old employer tries to get crafty and asks you to sign a release of all claims, saying that you will not sue them for anything that you could sue them for. I would advise you against agreeing to sign that. You shouldn't sign a release of all claims, because potentially, say your new employer does terminate, for instance, scenario, you're entitled from your old employer to 24 months of severance. You start working for your new employer, they decide not to keep you after 3 months. They pay you whatever they agreed they would pay you, 8 weeks. But that doesn't mean that you can't go after your old employer for the remaining 22 months that you would have gotten otherwise. But if you sign a release for your old employer, then you'll be closed off from doing that. What I just told you sounds a little bit complicated. What I'm trying to, if there's one takeaway here, is if you're presented with a new job offer from the new buyer and it comes with an employment contract, have that reviewed. Call us up. We're at employmentlawyer.ca. Employmentlawyer.ca is how you get in touch with us. Schedule a consultation. We'll do a contract review for you, tell you what your options are, all right? And point out what you're signing and what that could lead to down the line in terms of ensuring that your job conditions, salary, and working conditions and duties don't change, and that they can't get rid of you too easily with paying you very little or no severance. So you want to keep your options open. Know what you're getting into when you sign up with a new employer. We have another question coming in from WMC. WMC is asking, WC policy says that if you are injured at work because of an unsafe work environment, they are not responsible. Is that true? I'm not an expert on WCB, frankly, WMC, but I would doubt that that's the policy. Generally, WCB covers any workplace injury that happens at the workplace. And the trade-off there is that you can't sue your employer directly. So for instance, you get into a car accident, you sue the other driver and their insurance company, right? You get into a workplace accident, you can't sue your employer. Instead, you go to WCB. If your claim is approved, you can get WC benefits. But you can't sue your employer for whatever injury you suffered, workplace injury. That's the trade-off that was agreed to when WC programs were created throughout Canada. So if something happens at work and WC says, well, because it was unsafe, you've lost coverage, then theoretically you'd have to be able to go after your employer to be able to sue somebody. You should, if you're injured by somebody else's fault, there should be a way for you to obtain compensation. It's either going to be through WCB or it's going to be through suing your employer for the accident. All right. WCB, whether it be in Ontario, Alberta, or BC, they all have different names in the different provinces. They have hotlines, they have call centers that you can call to explain that. So I'm not exactly sure where you saw this, but WCB, its regulations and all that are very complicated, and it might be worth calling up WCB to make sure you fully understood what it said there. All right. So definitely reach out to them if you're wondering about that, if you've been injured at work, because that would surprise me. There have been very unsafe work environments out there, as you can imagine, very unsafe. Unfortunately, they've led to deaths and very serious workplace accidents, and they're terrible and they shouldn't happen. And occupational health and safety and WCB work very hard to make sure that accidents don't happen in the first place. So it would surprise me that they would leave an injured worker high and dry because the employer is doing something that's unsafe. That's precisely why WCB is there, because unfortunately some work is unsafe and it results in injuries. We have another question coming in from Mark P. Mark P is asking, my company just came out of CCAA protection. I've been with the company for 1 year. They're not doing my yearly review, and I have sent a new contract, and I must find by the 15th of this month. Help. All right. So, Mark, I think you might be in a similar situation to Linda B, in that probably during the CCAA proceedings, for those of you who are not familiar, CCAA proceedings are similar to a bankruptcy. They allow for debtors, companies that have too much debt, to restructure their debt, and oftentimes there's a sale of the company at a reduced price to keep the company going as a company. The debts get canceled, etc. Or get part of them do anyways. And the company keeps on going as a going concern. And that's great for employees and all of that, because they continue to have a job. Part of this process can mean that that a new owner comes in and wants to put everyone on contracts. So again, my advice to you would be, Mark P, would be to get that contract reviewed. Generally, once you're in a job, it's hard for the employer to force you to sign the contract. You can tell your employer, no, I don't want to sign this contract. I am happy to continue working for you, but I don't want to sign this contract. I will continue to work without a contract. All right. And the employer then has the choice of either accepting that you continue to work under the contract that you've already had, which could be an oral contract, which means that you never signed a written contract, or terminate you. But if they terminate you, it'll be on a without cause basis. It's not just cause to terminate an employee who refuses to sign an employment contract generally. All right. So they'll have to pay you, terminate you without cause, and provide you with severance. Okay. And again, I was discussing already, if you're trying to find out how much severance you might be owed, visit pocketemploymentlawyer.ca and figure out how much severance you might be owed. An important criteria on how much severance you're owed is how long you've been with the company. You were just telling us here, you've been with them about a year. So unless there are really exceptional circumstances, I don't think necessarily you'll be a candidate for the full 2 years of severance. But employees of short service are often entitled to more months per year of service proportionally than longer service employees. For instance, to give a scenario, you've been with a company 40 years. Let's call it 36 years. All right. And you get terminated, you would be entitled potentially to 24 months of severance, which means that you get 2/3 of a month per year of service, right? But oftentimes, employees that are employed 1 or 2 years might get 1.5 or 2 months per year of service, or even more, because it's just the fact that no matter how long you've worked somewhere, even if it's a couple of weeks, you're not going to find a job, in 3 weeks, right? Realistically, for most people, right? It's going to take 3, maybe 4, maybe 6 months in the best of cases, and judges recognize that. And that's why shorter term employees proportionally get more severance months per years of service than longer term employees. Because I often get that question, right? People ask me, well, what is it, Luc? How much severance does an employee get? Is it a week per year? Is it 2 weeks per year? Is it a month per year? I hear different things. And this is what I'm telling you. It's that going by years of service is not enough. That's not all that we look at. We've factored in the 4 main criteria that people look at, that the courts look at in determining how much severance you're owed. And they're boiled down into our questionnaire that we have. 4 easy questions allows us to give you a better understanding of how much severance you might be owed. So it's not so simple as just saying, well, it's all connected. It's all connected to how many years you work. There's other criteria as well. All right. We have another question coming in from Peter Ibbotson. If I have a contract with a previous company that got bought out by the current company I'm working for, does that initial contract still come to the new company? I would tell you that yes, Peter. So if you signed a contract with company A got bought by company B didn't make you sign a new contract with them, then yes, that contract would still be enforceable against you. And so you might be wondering, well, that termination clause that I signed in company A contract, is that still enforceable against me if I get terminated by company B? I would say yes. All right. Now, we've talked about termination clauses a few times in the show. More and more employees are being asked to sign contracts, and the main reason they're being asked to sign contracts is so that they agree to a termination clause that limits their severance entitlements when they're terminated. A lot of employees don't even realize that they are entitled to substantial sums if they're terminated usually, and these termination clauses are there to limit how much of those sums you receive. But if you are, fearing that you might lose your job or something like that, and you're looking back at your paperwork and you find the contract and you see there's a termination clause, don't think necessarily, all is lost. I signed a termination clause, I'm cooked. You're not, all right? A lot of termination clauses get overturned, are held to be unenforceable for a variety of reasons. Very legal reasons that are too complicated to get into here in the show. But what I want to tell you, if ever you're confronted with the fact that you've just been terminated or being offered a severance package that you find is very unfair, and the employer is talking about this contract that you signed when you started working or at any point in the past, this is time to pick up the phone, speak to us, show us the contract, let us look at that clause. A large proportion of termination clauses that I look at on a daily basis, I find are unenforceable rather, okay? And so they don't limit your termination entitlements. And you can go after the full severance that we describe at pocketemploymentlawyer.ca. So if you're looking to reach out to me, the website was on the screen, employmentlawyer.ca. That's how you get in touch with me. Let us take a look at that termination clause in your employment contract. You'd be surprised at how many of these clauses turn out to be completely unenforceable. So Linda B is following up. Linda B was asking us earlier about the company that was being sold. Linda B follows up. Thank you. So I should expect to receive a new contract. What if there's no new contract, but they expect me to keep working? Can the new employer change my position or reduce my pay? Great question. Great question, Linda. Well, a few things to know, okay? So this kind of varies from province to province, but in BC and Alberta, if your new employer takes you on without an employment contract, unless they specifically put it in writing that they're not recognizing your past years of service, then it's assumed that they are recognizing your past years of service. So you don't need to go after them or make sure that they put in writing that they're recognizing your years of service. In BC and Alberta, it's assumed that that's the case unless they say otherwise in writing. Okay. In Ontario, it's a bit more complicated, unfortunately. But there's still ways to make sure that your years of service do get recognized when we're trying to figure out your termination entitlements. Now, can they change your duties and your wages and stuff like that? So they can to an extent. All right. So essentially, it's not open season to give you a completely new job. All right. If they make a dramatic change, they demote you, they cut your pay, they change your work location, anything like that that's really crazy, you can just not take the job. You can say, well, this is not the job I had. I'm not accepting this new job offer. In which case, you are being terminated by the seller, and the seller owes you severance. All right, that's the way it works, right? If you take the new job, say for instance, they say, well, we want to keep you same everything, except we want to cut your pay by 50%. All right, you have two options. You can say, well, I am actually not taking a 50% pay cut, and I'm just going to go after my previous employer for my severance. Or even potentially you could take the new job and sue the previous employer to get a top up to what you were earning before for the period of time that you would otherwise get severance. So if the pocket employment calculator is telling you you'd be entitled to 12 months of severance, you can say for the 12 months following your hire date where you're being paid 50%, your former employer would have to top you up to what you were making before. All right. So that's just a quick calculation, but essentially what that means is your former employer would owe you, 6 months of wages. But if that happens, Linda B, again, a great reason to call us, okay? Because navigating these drastic changes to your employment conditions, you do need a little bit of a sure hand by your side to make sure you don't say the wrong thing, right? Because how many times do we end up reading about cases that gone to trial that are and the most relevant documents are emails and text messages, all right, and those emails and text messages are sent by non-lawyers, which is a term that we shouldn't use as much as we use as lawyers, but are sent by people like it'll be your manager and the employee who think they understand the law based on things that they've picked up from, their colleagues or neighbors or something, and they're taking legal positions without really understanding the legal ramifications of what they're saying. And it goes into an email or a text message, and people are claiming rights they don't have, or people are denying rights that they shouldn't deny, and all of a sudden you're in court, and it all boils down to an email that was sent that was based on an incorrect legal position because not one of the parties didn't consult a lawyer. So especially when it comes to a situation like this where they're making drastic changes to your job, get in touch with us and do it sooner rather than later. All right. If you wait a year, you take this new job. Listen, I'm going to try it out. I'm going to wait a year, see what happens. After a year, like, actually, no, I'm not thrilled with the new work environment. I don't like the culture or whatever. I'm going to claim that change that they made a year ago, I'm not okay with it. I'm going to tell them to pay me severance. You might be out of time. All right. Frankly, you have to, if you have an issue with a change that was made to your job, you can't sit on it. You have to do something about it quick. Okay. And the best thing to do is get some legal advice and have us guide you through the process of getting you to where you want to go, which is either making sure that change that they are proposing, that the employer is proposing, they give up on that, or that they pay you a severance because you're not willing to work under these changed terms. Okay. So be sure to reach out to us sooner rather than later. All right. We use this maxim a lot, but it's especially true in law. An ounce of prevention is worth a pound of cure. It really is. We have another question coming in from YouTube from Ugmas. Ugmas is asking us, if your employer has agreed to start a return to work program with you and does not bring you back to full-time after completing the part-time period, is there anything you can do? Well, I'd like to get a better understanding, Ugmas, of why they don't want to bring you back full-time. If they're telling you, well, we actually don't have full-time hours anymore in the position that you had. So my understanding from what you're telling me, Ugmas, is that you had to take some sort of time off due to some sort of disability, and we're ready to go back to work on a graduated return to work. You've gotten to the end of the graduated return to work and should be able to work full-time with no restrictions or with restrictions that can be accommodated by the workplace, but they don't want to give you all your hours back. Well, that, depending on how many hours, but it looks like if you're part-time, it's a substantial amount of hours, that can amount to a constructive dismissal. You can say, well, listen, my job with you is a full-time job. If you're not going to give me full-time hours, then I'm going to quit and treat it as a constructive dismissal, which means that even though I quit, you owe me severance. Simple as that. And if the cut in hours is drastic enough, and it doesn't have to be super drastic, we're talking about 10 to 15% of your hours are cut. If they cut one day, that's 20%. That already is constructive dismissal. So if they say, well, we're going to cut you from 5 days a week to 4, and you were working, 8 hours a day prior to that, that's a constructive dismissal. You don't have to accept that. You can claim your severance. And depending on why your hours were cut, maybe they hired someone while you were away, they like that person better, or even they not like them better, but they don't want to lose that person. That could amount to disability discrimination. You might have claims under human rights legislation as well. Mark P is following up. Mark P is saying he's calling our auto office. Good call, Mark. Yeah, good call. Call our auto office. Mark was the one whose employer was going through the CCAA proceedings. I think it's important that you get that contract reviewed. Last thing I'll tell you, Mark, the 15th is coming pretty quickly. I would tell your employer, you can be upfront about it. Listen, I'm trying to get this contract reviewed by a lawyer. I need more time. Can I get an extra 2 weeks? And honestly, if they're asking you to sign an employment contract, they should be okay with allowing you to get legal advice. It's the least you can do. All right, time for one last question. Thank you all for joining in. We got one last question left. If you have any other questions left after I take this last question, be sure to tune in on Thursday, where my colleague Alex Lucifero is conducting an employment and disability law Q&A. Mark, you'll be especially interested because Alex is the managing partner of our Ottawa office. So he'll be tuning in at 12:30 p.m. Eastern Time. If you have employment questions, if you have disability law questions, long-term disability, short-term disability, feel free to tune in. We'll get to as many of those questions as we can. Last question coming in from Jessica Backer Ayers is asking, after nearly 3 years of tenure, I was terminated without cause 2.5 weeks after letting my VP know that I'm pregnant. What are my options? Okay. Your options, Jessica, are to call us, frankly. We want to know a little bit more about this. So if you are terminated because you were pregnant, then of course that can't be for cause. So you'd be owed your severance because you were terminated on a without cause basis. But you have other claims as well. All right, you have claims under human rights. It's a human rights discrimination to terminate someone because they're pregnant. All right, and one of the options that you can get through human rights is to be reinstated in your position. I'm sure you are very concerned right now of whether you'll be able to claim EI while you're on maternity leave. You might want to reach out to EI to get the full details of that, how that's going to impact your maternity leave eligibility. But you have substantial entitlements now. So I think it's important you reach out to us. Best way to reach out to us, as always, no matter what part of Canada you're in, we represent employees in BC, Alberta, and Ontario, is employmentlawyer.ca. You get in touch with us, we will get someone in one of our offices to reach out to you as promptly as possible to help you out with this legal situation you've been in, which probably comes at the worst of times. I mean, this should be a happy moment for you, and to throw in this uncertainty into your future is really quite drastic. So reach out to us, Jessica. We want to hear from you. We want to help. For all of you, thank you for tuning in to the show. Once again, we're back on Thursday at 12:30 p.m. Eastern Time. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm also the Western Canada Employment Practice Lead. So thank you for joining, and I will see you next time.